We do have one more case on our docket this afternoon. And that is case number 250297, Molly Pumphrey as the executor of the estate of Rebecca Lynn Myers and on behalf of Jennifer Latham and individually appellants versus Clarinda Regional Health Center, Cassandra Mellett, PAC, Jordan Cave, and Ryan Fee, Appellees. The appellants this afternoon will be represented by Counsel Gary Mattson. Appellees Clarinda Regional Health Center and Cassandra Mellett will be represented by Attorney Jeff Wright. And the appellees Jordan Cave and Ryan Fee are represented by Attorney Michael Story, who will not be arguing this afternoon. Is that correct?
Yes, Your Honor.
All right, thank you. All right, Mr. Mattson, whenever you're ready.
Thank you, Your Honor. May it please the court. Mr. Wright, Mr. Story. I represent Molly Pumphrey and the estate of Rebecca Myers. This is a medical malpractice case. At issue here is whether the district court erred in finding that the savings statute, Iowa Code Section 614.10, did not apply to this case by reason of negligence in the prosecution of the plaintiff's initial cause of action. In order to answer this question, the court must determine whether the plaintiffs were reasonable in concluding that their certificates of merit substantially complied with Section 147, 140 of the Code without the benefit of the Iowa Supreme Court's decision in Miller v. Catholic Health Initiatives.
I'm just going to throw this out there. The plaintiffs, Miller, didn't have the benefit of Miller either, but I don't think the Supreme Court found that their interpretation of the statute was reasonable. Am I off base on that?
I don't think you're off base on that, Your Honor. They didn't have the benefit of that. Their certificate of merit that they filed, or they alleged they filed, was an opinion letter from a doctor at Johns Hopkins. It also did not have a jurate or penalty of perjury language. So it was somewhat different than the certificate of merit that we submitted in our case initially, which was in an affidavit form and provided that the expert witness did sign that under oath and affirm that as well. It did not have a jurate or did not have the penalty of perjury language that Miller and subsequently Banward relied upon as being necessary to substantially comply with 147, 140. In this case, Rebecca Myers died October 4 of 2020. The case was filed in April of 2022. The three experts who signed certificates of merit signed them 3 days, or they were served and filed 3 days after the defendant's answer. Discovery was undertaken, as typical. These experts were deposed in the summer of 2023. They were not questioned about their certificates of merit. The trial was scheduled for October 1 of 2024. The Miller case came down in May of 2024, and the defendants filed their motion for summary judgment at that time, alleging that the certificates of merit that we had filed did not substantially comply with 147, 140. In reviewing Miller and other cases concerning the certificate of merit statute, it was clear that they did not substantially comply, and that our case had failed for all practical purposes. And so the plaintiff went ahead and dismissed our case without prejudice and refiled it 3.5 months later in accordance with the savings statute, Iowa Code Chapter 614.10. The defendants resisted the motion, or the defendants filed a motion to dismiss, and we resisted, and the district court ruled that the prosecution of the underlying case, we were negligent in the prosecution of the underlying case. It could not utilize the savings statute. In doing so, the court didn't define negligence in the prosecution. That specific term appears in 614.10. And the statute does not define negligence in the prosecution. What we point out in our brief is that the Iowa Supreme Court, in addressing this issue over the years, has said that they've used a reasonableness standard. It's been referred to reasonableness and unreasonableness, so we would suggest that the court should adopt a reasonableness standard in determining the plaintiff's conduct in the prosecution of the underlying case.
Assume we're going to use something like that standard. You know, obviously, we are only coloring within the coloring book the Supreme Court has given us on this issue. They've repeatedly said the statute is unambiguous, and everybody should have known that an affidavit was required, and whether you or I agree with that, I guess, doesn't matter at the end of the day. If they say it's unambiguous, how was your conduct reasonable?
I still think we can say that in the context of looking at it through the saving statute lens, with the evidence that we produced and the other case law that's out there, obviously they've said that it is unambiguous, but there are plenty of cases out there in the wake of Miller that have come up where we've seen that this was a fairly common practice.
With you there, but aren't we stuck with what the Supreme Court has said about unambiguous?
They have said it's unambiguous. I still say that you can still say that plaintiffs in our position were reasonable in interpreting the statute a different way.
Wouldn't we have to find that it's reasonable for lawyers not to follow an unambiguous statute in order for you to win? And I'm sure you get from my phrasing why that's a troubling proposition for me to throw out.
It's difficult, and that's a question we've pondered, Your Honor. But I think with what I was getting at was at the district court level, the defendants cited, I think, 8 Iowa district court cases where plaintiffs had resisted motions for summary judgment in the wake of Miller. And what they had in common was they had filed certificates of merit that lacked the jurat, lacked the penalty of perjury language, just like ours. I think 4 of those cases have come before you, this court. So we know what the results were. My point is these plaintiffs and these lawyers were in substantially similar circumstances that plaintiffs here. And I'm saying that means something, that was a common pattern in practice. Apparently, when that many cases fall by the wayside in the wake of that decision. And that's my position, that so many were involved in that and had the same conclusion. I get what you're saying, but that's where I'm coming from.
And I have sympathy, and you're right, we keep seeing these cases, but is the relief you're really after going to have to come from the 4th floor instead of us if we're stuck with this unambiguous language?
It wouldn't surprise me.
That's a fair answer, and I appreciate it.
And I appreciate that, but that's what we're left with. And when I reference these cases that have come before you, that were cited by the defendant, yes, that suggests that this is a fairly common practice under similar circumstances.
Counsel, do you think the standard for lack of negligent prosecution here is the same as like the legal malpractice standard? So if we were to find that it was reasonable here, does that also mean that it would not be possible for someone to bring a legal malpractice lawsuit based on this?
Well, I think anybody can bring a legal malpractice lawsuit.
Legal malpractice.
I think the legal malpractice standard is a little more strict. I think that
What's more strict?
I think it would be better for us if it were a legal malpractice standard in our current situation, because you're dealing with a situation where, and again, this comes back to your question, Your Honor. It's reasonable attorneys acting, in a usual manner, and you're dealing with a case that interpreted the law in a certain way. Granted, the court has said that it's unambiguous, but it was different, and many other people were practicing in a different way. So
Why wouldn't that be the standard that should be applied here under this statute too?
that the court has never done that. I've looked at every single savings statute case, I think, in the history of this state, and I haven't seen any reference to that. It's just been a reasonableness or diligent standard that they've used. So,
Because it's more often like a statute of limitations question versus something that's like a discrete statutory requirement. I think these are a little unusual as far as what we're talking about with the savings statute, but maybe you disagree, and I invite you to.
I don't know if it's that, or it could very well be that's the issue that they've addressed, but they've never used a legal malpractice standard. But I see my time is up. Thank you.
Thank you, Counsel. You will have 5 more minutes on rebuttal. Counsel? Whenever you're ready.
Thank you, Your Honor. May it please the court, counsel, Mr. Story. Your Honors, we're here today before the court on appeal of a motion to dismiss ruling that's reviewed for corrections of errors at law at the district court level. We'd submit to the court that there are no errors at law by the district court. The plaintiffs have taken a unique approach to the certificate of merit saga that, as Judge Buller noted, you guys see with some frequency by choosing to just dismiss their case and refile and try to slide around certificate of merit and take advantage of the savings statute. The district court said you don't get to do so because of the negligence of your actions in prosecuting your case. A failure that the plaintiffs have readily acknowledged, that they didn't have a certificate of merit that was compliant with Iowa Code 147-140. Fernald is the, I would describe as the seminal case, at least of recent times, on the issue of the savings statute. Importantly, it makes note near the end of the opinion that the statute was designed to protect plaintiffs only from getting ensnared in fatal, technical, procedural problems that could not or cannot be avoided through due diligence.
Jump off that to the discussion we had with your opponent, which is this the malpractice standard? Is it something else? Does it matter?
So it's not the malpractice standard, and I don't remember which of the cases that talks about it specifically, but one of the Supreme Court cases specifically says this is not the legal malpractice standard. The question that it feels like the plaintiffs would prefer to take advantage of is for a legal malpractice case. And the reality is, in these cases, there's some discussion about a reasonableness standard and what was everybody else doing. But the Klingensmith case from 1964 actually addresses this from our perspective about what reasonableness means and what and it really describes the statute as a due diligence statute. The purpose and the requirement of the statute is a rule of diligence, and there's discussion about this preference for cases to be heard on the merits, but that only goes so far according to the Supreme Court in Klingensmith. They say, the court says that preference does not help a plaintiff that has ignored a plain mandate with ample opportunity to have abided by it. And the idea that reasonableness should be something different than were they diligent or weren't they diligent? Would diligence have prevented this problem, or would it not have prevented this problem? And in this instance, for purposes of this statute, that's how the Supreme Court has defined, if you want to use the term reasonableness or negligence.
So the case that I found that I thought maybe was sort of the hardest case for you was Wilson v. Wright, and that's the one where they got led into the clerk's office after hours to try to file on time, but then it turned out that the statute actually said it's not really filed until the clerk does a memorandum, and there they said that was an obscure technical sort of thing. You know, it was wrong, wouldn't have been reasonably diligent, but it was reasonable to not do that. Like, how is this different than that situation?
Let's start with what the statute requires of a plaintiff's lawyer in a malpractice case that's existed unchanged since 2017, using the word affidavit 6 times in the statute and specifically stating this must be done under oath. In the case you're describing, a situation where they're at the clerk's office, they're utilizing the clerk, that's sort of a technical thing that's beyond their control. And that's really what the test is here, I think, are they faced with something that's truly beyond their control?
So why shouldn't we give some weight to the other district judges that ruled this way? I mean, in the Banwart case, 2 Supreme Court justices said that this would meet the substantial compliance standard of the statute. When there's that amount of debate, why wouldn't we say this was, a mistake, but a reasonable mistake?
Again, definition that's been given, I guess, by the Supreme Court as it relates to this statute. They use the phrase that this is a narrow and sharp test as opposed to broad and blunt. That's a phrase used in the Fernald case. And you have this situation where, for purposes of this statute, it's only reasonable if it could have been prevented with due diligence. And with all due respect to plaintiff's counsel, who we do have good respect for, I don't want to sound like I'm taking shots, but it's following directions. The statute said what to do, and they had the opportunity to do it, and they didn't.
Stepping back just a little bit from the standard, normally reasonableness is a factual question. I'm struggling a little bit with sort of how we're here on a motion to dismiss and resolving whether it was reasonable or not, at a motion to dismiss stage.
That's a fair question. And I'd refer the court back to the Klingon-Smith case and how they've analyzed it, and the language of simply due diligence. Attempting to use the saving statute is not contemplated or appropriate under the clear language of the code. We've got language from the Supreme Court on multiple occasions, this court as well, saying it's unambiguous. It's clear what was required. And so a failure to do so, negligence or reasonableness, the Klingon-Smith case specifically tells us what the standard is when the word negligence is used in the statute. And they throw around the term reasonableness through that opinion for sure. But then they say it's due diligence. Could this have been avoided by due diligence? And if so, it's a kind of a hard stop. This doesn't apply. And so you find we find ourselves in a spot where the statute says what's required. It says it explicitly as to what's required. The Supreme Court in the Miller case and its progeny since then have all said this is unambiguous and clear, and it was and will always be required. There's a comment in the case of, it's not that we don't trust the expert who was involved in that case, but we're also not going to question the legislature when they insist that it be signed in person and under oath. And so reasonableness to your question, and is it a fact question or isn't it a fact question? In the context of 614.10, the Klingon-Smith case says if this could have been avoided, then it is negligent. They've defined it for purposes of this statute. That Supreme Court decision says this is how we evaluate this. There's no court anywhere ever that has said that the idea of whether a lawyer was or a party was negligent in the context of prosecution of an underlying case, never has it been articulated that it's a a fact question to be decided by a fact finder after an evidentiary hearing of some kind.
Say, to take advantage of the saving statute, it's the plaintiff's burden to plead and prove, which sounds like a fact sort of thing, and many of them are resolved on summary judgment or stipulated factual records rather than motion to dismiss. But I guess I just want to make sure I understand. Is your position it's not a fact question, or just that there's no fact dispute here because it's so clear that it's negligence?
I think it's the latter, and essentially the standard for a motion to dismiss under the facts pled, is there any scenario under which the plaintiff could put forth a prima facie case? And the district court correctly concluded, no, there's no way that you could do that because this statute required a certificate of merit that substantially complied, and you failed to do so. There is no path to a prima facie case that can survive the necessary scrutiny, and so it was appropriately dismissed on summary, or on a motion to dismiss.
Are we required to close our eyes to the fact that we keep seeing these cases and seeing what I consider often very good plaintiffs' lawyers that have fallen into this trap?
Is it all right that I finish since I'm? You may go ahead. Okay, thank you, Your Honor. No question that there are good lawyers who have fallen into this trap as the courts described it. I think the fourth floor would say really not a trap because the legislature told you what to do and you didn't do it that way. And to the court's question earlier about Miller, well, the Miller plaintiffs didn't have the advantage of Miller either. Everybody had the advantage of the statute and the language of the statute, and the statute specifically says the expert must sign this under oath in person. I mean, these are the words of the legislature, and we're kind of held to the standard of understanding what the legislature says. And so, I mean, I don't disagree with the court at all that I mean, every time you guys have a session, it's probably one of these cases that comes before you. And but the reality is, in this instance, on this case under 614.10 and the others, the statute told them what they were supposed to do, and that wasn't followed. Thank you.
And you have 5 minutes on rebuttal at this time, counsel, whenever you're ready.
And we too have great respect for defense counsel in this case. But if the statute was clear to everyone from the very beginning, a reasonable question might be, why didn't the defendants file a motion for summary judgment 2 years before to effectuate the purpose of the statute, which is to weed out frivolous lawsuits? That wasn't done. So my suggestion is that many of these defense attorneys waited until the Miller decision, when it became clear to everybody what the law was and what the requirements were. We cite in our brief, in a footnote, the SK decision, which the Supreme Court decided and which was remanded back. In that case, the defense counsel waited until after trial and a judgment against the doctors, and waited until the appeal to file a motion to dismiss under the Miller decision.
And I think that's a fair criticism. Where I'm just really stuck in this case, and maybe this is a question I've already asked you, I'm just asking it a different way, but how can I get to where you want me to go under the existing case law the Supreme Court has given me?
All I can say is I think under the uniqueness of the saving statute, I think you can say that under this statute, we were still reasonable in our conclusion. And that's the best answer I can give you, Your Honor. And I wanted to touch base on a couple of things that Mr. Wright brought up. The Klingon-Smith case that he's relying on is something we can discard that, or it's much different in this case. That was on a 215.1 dismissal. The lawyer simply disregarded the order of the court or the order of dismissal, and the saving statute did not apply there. I just point out too, Judge Langholz brought up the fact that the dissent in the Banwork case Justice McDermott and Justice Oxley, I believe now, would say that certificates of merit that we filed initially in our initial case would substantially comply. The Banwart District Court judge did not have the benefit of the Miller decision granted, but that district court judge said that did comply, that it was substantially complied with the statute. So those are the arguments that I make, is that somebody's not getting the memo here. And it's just what it is. There's a lot of lawyers involved in this. There's district court judges, there's plaintiff's counsel, there's defense counsel, and now it appears that maybe there's Supreme Court justices too. I want to talk 1 minute about the Fernald decision and the narrow and sharp argument about the saving statute. The Fernald case does mention narrow and sharp focus. It cites, I think, the Phoenix case from way back when. I would say that if the court looks at the Rivera versus Woodward decision, which doesn't deal with 614.10, it deals with the saving statute associated with 669 of the code. But they do cite Fernald, and they cite saving statutes generally, and they cite a liberal type of interpretation. And they do say that the purpose for the saving statute is to give a diligent but mistaken litigant an opportunity to have their case tried on the merits. And I think that still applies to this case. So I'm here to say that based on the evidence in this case, the pleadings and the evidence showed that plaintiffs were diligent in their original cause of action, and that the failure of the action was not due to the negligence in the prosecution, that the plaintiffs, by their pleadings and the evidence in this case, have brought themselves within 614.10 of the code and have stated a cause of action. The decision of the District Court of Page County should be reversed. Thank you.
Thank you both for your briefing and your arguments today. This case will stand as submitted, and we will have a ruling out as soon as we are able. That will conclude this session of our arguments. There will be additional arguments tomorrow, and we will stand in recess until the court is convened with a different panel tomorrow morning.